His name was Jordan Belfort. You probably know him as the Wolf of Wall Street. In 1995, his brokerage firm, Stratton Oakmont, sued an internet company, not for hacking them, not for stealing their data, for something a stranger wrote on a message board about them. And the judge agreed with them. That decision, from a single court in New York, was so dangerous that Congress rewrote the rules for the entire internet within 12 months. Those new rules are called Section 230. You have never read them. You use them every single day. This is Docket Decoded, and this is the case that decided, once and for all, whether tech companies are responsible for what you post. To understand what happened, you need to picture the internet in 1994, not the internet you know. The internet before Google, before social media, before smartphones. The internet was bulletin boards, text on a screen, forums where strangers typed things to other strangers, slowly, over dial-up connections. One of the biggest internet companies at the time was called Prodigy. 2 million subscribers, 60,000 messages posted every day. Prodigy made a decision that most companies would consider responsible. They decided to moderate their boards, to delete messages that were offensive, to clean up the conversation. That decision would cost them everything. In October 1994, an anonymous user posted something on Prodigy's Money Talk board. They claimed that Stratton Oakmont, Jordan Belfort's firm, had committed fraud in a recent stock offering. Stratton Oakmont and one of its executives, Daniel Porush, read the post, and they sued Prodigy for $200 million. Not the person who wrote the post, the platform that hosted it. Think about that for a moment. Someone you don't know writes something online. A company comes after the website that published it, not the writer. Sound familiar? That is the question at the heart of this entire case. In May 1995, the New York Supreme Court ruled, not in Prodigy's favor. The judge's reasoning was this: Prodigy had chosen to moderate their boards. They had deleted some messages. They had exercised editorial judgment. That made them, in the court's view, more like a newspaper editor than a library shelf. And newspaper editors are responsible for what they publish. Prodigy had tried to be responsible, and the court had punished them for it. The ruling sent a single, devastating message to every internet company watching: if you moderate anything, you become liable for everything. To understand why the Prodigy ruling was so catastrophic, you need to understand one distinction in media law: the difference between a publisher and a distributor. Here is the simplest way to understand it. Imagine a bookshop and a newspaper. The bookshop stocks thousands of books. It doesn't read them all. It doesn't edit them. It just sells them. If one of those books contains a defamatory lie, the bookshop is not liable. It's a distributor. It had no knowledge of the content. The newspaper, on the other hand, employs editors. It chooses what to publish. It reviews its content before it goes out. If it prints a defamatory lie, it is liable. It's a publisher. It had control. Before Prodigy, courts had already decided that CompuServe, another early internet company, was a distributor. CompuServe didn't moderate anything. It just hosted everything. The court said, they don't know what's on their platform, so they can't be held responsible. Prodigy tried to do better. They hired moderators. They deleted offensive posts. They held themselves out as a family-friendly service. And for that effort, the court called them a publisher. The rule the Prodigy case created was perverse. The more you try to clean up the internet, the more legally exposed you become. Equals 800. Still with me? Because this is the moment Congress read the judgment and picked up the phone. Two members of Congress, Representatives Chris Cox and Ron Wyden, read the Prodigy ruling and saw exactly what it would do to the internet. If every platform that moderated content became a publisher, companies would have two choices. Option 1. Moderate nothing. Become a suer, but avoid liability. Option 2. Moderate everything. Become responsible for every single post. Hire armies of reviewers. Go bankrupt. Neither option would produce an internet worth using. Cox and Wyden wrote a 2-page amendment. 26 words of protection. Congress passed it in 1996 as Section 230 of the Communications Decency Act. The key sentence reads, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider." 26 words. Every social media platform in existence today exists because of them. Section 230 worked spectacularly. Within a decade, every major platform that now defines modern life, Google, YouTube, Facebook, Twitter, built their entire business model on the assumption that Section 230 would protect them. Your review on Google, your post on Instagram, your comment on YouTube right now. None of these could exist at scale if platforms were legally responsible for every word. But as social media grew, and as the harms became impossible to ignore, politicians on both sides started asking the same question. Should a company that knows harmful content is spreading on its platform, and does nothing, really be protected by a 1996 law written before the smartphone existed? In 2023, the Supreme Court was finally asked to answer that question. The case was Gonzalez v. Google. Reynaldo Gonzalez's daughter Naomi was killed in the 2015 Paris terrorist attacks. Her family sued Google, arguing that YouTube's algorithm had actively recommended ISIS videos to potential recruits, not just hosted them, recommended them, targeted them, amplified them. The question before the Supreme Court: does Section 230 protect an algorithm that chooses what you see, or just a platform that passively hosts what you post? Before I tell you what the court decided, if this case is making you think about what the internet would look like without Section 230, send this video to someone who needs to know, because what the Supreme Court did next is something almost no one reported correctly. On May the 18th, 2023, the Supreme Court issued its ruling, and it said, "We are not going to answer the Section 230 question, not because the question wasn't important, but because the Gonzalez family's underlying terrorism claim would fail regardless, based on a separate case decided the same day." So the court took the exit ramp, left the Section 230 algorithm question completely unanswered. Think about what that means. The 9 most powerful judges in America, the ones whose job it is to settle the hardest legal questions, looked at Section 230 in the age of algorithmic recommendations, and blinked. The question of whether YouTube's algorithm is protected by a law written in 1996 remains, to this day, unanswered. Here is the honest answer. Every piece of content you see on social media, every recommendation, every suggested video, every, you might also like, is currently protected by a legal shield that was never designed for the algorithm era. That shield may be narrowed by Congress. It may be challenged in a future Supreme Court case. A bill to sunset Section 230 entirely was introduced in the U.S. Senate in 2026. But right now, as of today, Section 230 stands. The original Stratton Oakmont case was settled out of court in October 1995. Before Section 230 even existed, Prodigy never had to pay Belfort's firm. The case was mooted, but the damage was already done, and Congress had already reacted. Section 230 effectively reversed the Prodigy ruling as a matter of federal law. Had it applied in 1995, Prodigy would never have been considered a publisher in the first place. And Stratton Oakmont. The firm collapsed in fraud. Jordan Belfort went to prison. His lawsuit is now a footnote, except that its footnote created the legal foundation of the modern internet. Section 230 is now under more political pressure than at any point in its history. Left-wing critics say it protects platforms that amplify misinformation and hate. Right-wing critics say it lets platforms censor conservative voices without accountability. Child safety advocates say it shields companies from liability when their products harm teenagers. For the first time, there is bipartisan support in Congress for either repealing or fundamentally amending it. The law that Belfort's lawsuit accidentally created, the law that built the internet, may not survive the decade, Now here is the part that matters if you are watching from outside the United States, because Section 230 is an American law. The rest of the world, which uses the same platforms, shows a completely different approach. In the United Kingdom, the Online Safety Act, passed in October 2023, took the opposite philosophy to Section 230. Instead of protecting platforms from liability, it imposes a legal duty of care. Platforms must proactively assess and mitigate risk. Ofcom can fine companies up to 10% of global revenue. Senior executives can face criminal prosecution. The UK chose accountability over immunity. In Australia, the Online Safety Act 2021 goes even further. Platforms must respond to harmful content takedown requests within 24 hours. The eSafety Commissioner has powers to issue industry codes that are legally binding. Australia decided the American model was simply not aggressive enough. And in India, the rules of 2021 created a three-tier intermediary liability system. Platforms classified as significant social media intermediaries, those with more than 5 million users, must appoint a grievance officer, a nodal officer, and a chief compliance officer, all based in India. They must respond to government takedown orders within 36 hours. Miss the deadline, and they lose their safe harbor protection entirely. India didn't follow America. India didn't follow Britain. India built its own model, and it is the most demanding of any major democracy. Jordan Belfort spent 3 years in prison. The company he sued, Prodigy, no longer exists, but the 26 words Congress wrote in response to his lawsuit still govern everything you see online. The law is the same idea everywhere. Someone has to be responsible. The question is, who? I'm your host. This was Docket Decoded. If this case changed how you think about your feed, subscribe, and I'll see you in the next one.